The Supreme Court will be taking up a gun rights case.
First major Second Amendment case in decades.
The Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
Major ruling involving the Second Amendment.
It's a law that stood for more than a century, but the court has now said that that law cannot stand.
Now, this is the most significant Second Amendment ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Later today, a landmark civil rights case is set to be argued before the Supreme Court.
In the span of just one morning, millions of Americans woke up with rights they didn't have the day before. Not through legislation, not through executive orders, through 6 words that shattered a century of legal precedent. The Constitution means what it says. For over 100 years, law-abiding citizens walked into government offices, paperwork in hand, background checks passed, training completed, only to hear those crushing words, "Sorry, you don't qualify enough." No crime on their record, no threat to society, just a bureaucrat's personal opinion standing between them and their constitutional rights. That was the reality in places like New York and California. Citizens had to beg for permission to exercise rights that were supposedly guaranteed. They had to prove they deserved protection more than their neighbors. They had to justify why their lives mattered enough to defend. But everything just changed. In a landmark 6-3 decision, the U.S. Supreme Court didn't just challenge this broken system, they obliterated it. And if you carry, plan to carry, or simply believe in constitutional rights, you need to understand what this ruling just unleashed across America. Because this wasn't just a legal update, it was a constitutional earthquake. And the aftershocks are still reshaping the landscape of American freedom.
Members of the Senate are focusing on gun rights.
The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
Major Supreme Court ruling on New York's concealed carry regulations.
Most significant case regarding the Second Amendment in more than a decade.
This ruling strikes down a New York law that put restrictions on who could get a license to carry a gun outside of the home.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
The case that broke the system. The story begins with ordinary people facing an impossible choice. In New York, citizens who wanted to carry firearms for protection had to navigate a maze designed to defeat them. The state demanded they show proper cause beyond simple self-defense. You had to prove some extraordinary level of danger, like being stalked by a specific threat or facing documented harassment. Self-defense wasn't good enough. Personal protection wasn't sufficient. You had to convince a government official that your life was more valuable, more threatened, more worthy of constitutional protection than everyone else's. The New York State Rifle and Pistol Association challenged this system in a case that would reshape American law. They argued that requiring citizens to justify exercising a constitutional right violated both the Second and 14th Amendments. The government countered that public safety required such restrictions. When the case reached the Supreme Court, something remarkable happened. The justices didn't just rule on New York's specific law, they established an entirely new framework for evaluating all gun regulations across the country. Writing for the majority, Justice Clarence Thomas delivered a decision that sent shockwaves through the legal establishment. If a law restricts Second Amendment rights, it must be consistent with the Constitution's text, history, and tradition. Modern lawmakers can't simply decide what seems reasonable or necessary. They must ground restrictions in historical precedent from America's founding era. This new standard doesn't just affect concealed carry. It's already forcing courts to reconsider magazine limits, transportation restrictions, and numerous other regulations that couldn't survive historical scrutiny.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
Everybody has a right if they're a responsible adult.
The ripple effect across America. The decision didn't just change New York. It sent seismic waves across every state with similar restrictions. New Jersey, California, Hawaii, Maryland, and others had built entire regulatory schemes around subjective approval processes. Citizens in these states had been denied permits not for what they'd done, but for failing to convince bureaucrats they deserved constitutional protection. These may-issue systems gave local authorities unlimited discretion to deny applications. Sheriff's departments, police chiefs, and licensing boards could reject perfectly qualified applicants based on personal opinions, political preferences, or arbitrary standards that changed without notice. Now these states face a stark choice: comply with the Supreme Court's mandate or face endless litigation they're destined to lose. Many are transitioning to shall-issue systems where meeting basic legal requirements guarantees approval. No more begging, no more justifying, no more proving worthiness. But the transition isn't happening quietly. Some states are responding with what legal experts call soft resistance. They can't deny permits outright anymore, so they're burying applicants in bureaucratic quicksand. The bureaucratic backlash. In California, lawmakers are crafting legislation that redefines sensitive places so broadly that legal carry becomes practically impossible. Their new maps would ban firearms from virtually every public space, rendering permits meaningless. New Jersey and Massachusetts are developing suitability requirements that appear constitutional on paper but create insurmountable obstacles in practice. Extended waiting periods, expensive mandatory training, character references, and psychological evaluations designed not to ensure safety but to discourage applications. New York's response perfectly illustrates this strategy. After losing at the Supreme Court, they passed a revised law designating an enormous list of prohibited locations. Times Square, public transportation, parks, bars, libraries, houses of worship, and countless other areas became off-limits to permit holders. Critics argue this list is so comprehensive that legal concealed carry becomes nearly impossible even for those who jump through every bureaucratic hoop. When challenged, the Supreme Court chose not to intervene immediately, leaving the battle to continue in lower courts where legal challenges are actively underway. This resistance represents more than policy disagreement. It's calculated retaliation against citizens who dared to assert their constitutional rights. The new legal standard. The most revolutionary aspect of this decision is the legal framework it established. Courts can no longer evaluate gun laws based on modern policy preferences or contemporary safety concerns. They must ask specific historical questions. Does this regulation align with the Constitution's original text? Does it reflect how firearms were regulated during America's founding era? This text, history, and tradition standard sets an incredibly high bar for gun restrictions. Lawmakers can't simply argue that a regulation serves public safety. They must prove similar laws existed in the 1700s and 1800s. This requirement is already reshaping American jurisprudence. Federal courts have struck down magazine capacity limits, transportation restrictions, and various other regulations because historical research couldn't find equivalent laws from the founding period. The standard forces a fundamental question. If the founders didn't see fit to impose certain restrictions when they wrote the Second Amendment, what authority do modern legislators have to impose them now? Real-world impact for gun owners. For citizens in constitutional carry states like Arizona, Tennessee, or Texas, this ruling changes little. These states already respect Second Amendment rights and offer straightforward permit processes or allow permitless carry entirely. But for residents of restrictive states, this decision is transformative. Thousands of people previously denied permits under vague and subjective standards now have clear legal recourse. You no longer need to prove extraordinary danger or justify why you deserve protection more than your neighbors. However, victory isn't automatic. Some states are creating new obstacles faster than courts can strike them down. Higher fees, longer wait times, more paperwork, expanded background checks, and additional training requirements designed to slow the process and discourage applications. These tactics are being challenged in court, but legal battles take time. Meanwhile, citizens must navigate evolving regulations while asserting their newly clarified rights. The broader constitutional revolution. This case represents just the beginning of a broader constitutional reckoning. The new legal standard applies to all firearms regulations, not just concealed carry permits. Courts across the country are being forced to reconsider laws that previously seemed untouchable. Magazine capacity limits in California and New Jersey are under assault. Assault weapon bans based on cosmetic features face constitutional challenges. Mandatory waiting periods for citizens who've already passed background checks are being questioned. Storage and transportation requirements are under scrutiny. Early results are promising for gun rights advocates. A federal court has already struck down California's magazine capacity law using the new historical standard. Similar lawsuits are advancing in Illinois, Maryland, Massachusetts, and Oregon. As these cases work through the legal system, appellate courts, and eventually the Supreme Court will determine how far this constitutional restoration extends. But the precedent is clear. Modern gun laws must be rooted in historical tradition, not contemporary political preferences. The path forward. This Supreme Court decision opened a door, but it's up to citizens to walk through it and keep it open for future generations. Rights that aren't exercised tend to disappear. Constitutional protections that aren't defended tend to erode. Gun owners now play a critical role in determining how far this ruling reaches. That means staying informed about new local laws, speaking out at city council meetings, supporting litigation that challenges unconstitutional measures, and continuing to carry responsibly and confidently within the law. The opposition isn't surrendering. Anti-gun politicians are doubling down with new restrictions designed to circumvent the Supreme Court's mandate. They're crafting legislation that appears compliant on the surface but undermines the ruling's intent. This makes citizen engagement more important than ever. We need to support organizations doing the legal heavy lifting, like Gun Owners of America, the Firearms Policy Coalition, and the Second Amendment Foundation. These groups challenge unconstitutional laws in court and win, but it doesn't stop with donations. Share accurate information, talk to friends and family, help others understand what's happening. When we stay informed and engaged, we don't just defend our rights, we strengthen them for everyone. A constitutional moment. This wasn't just one Supreme Court ruling. It was a constitutional course correction that's been building for decades. The decision represents a fundamental shift in how courts interpret the Second Amendment, moving from a collective right subject to reasonable regulation to an individual right requiring historical justification for any restrictions. The $3 billion in bureaucratic infrastructure built around denying permits is crumbling. The century-old system of making citizens beg for constitutional protection is ending. The era of subjective standards and arbitrary denials is over. But constitutional moments require constitutional citizens, people who understand their rights, exercise them responsibly, and defend them vigorously. People who recognize that freedom isn't self-executing and democracy isn't self-sustaining. The Supreme Court has spoken. Now it's up to us to ensure their words become lasting reality. Because when constitutional rights are at stake, silence isn't an option, complacency isn't acceptable, and surrender isn't in our vocabulary. The door to constitutional carry has been opened. The question is, are we prepared to walk through it?